CommitToWealth.com, creating a legacy by committing to real estate wealth.
Commit to Wealth Nation, welcome to the Commit to Wealth podcast. I'm your host, Juan Vargas. On today's show, we have Jeff Love. So Jeff is an attorney and partner with Gibbs Giden, where he and his team focus on residential and commercial transactions, purchase and sale agreements, syndications, leases, pretty much you name it. His firm does it. So without further ado, Jeff, welcome to the show.
Thanks for having me. Excited to be here.
Hey, Jeff, it's a pleasure to have you on. And so, yes, we have a lot of things to discuss. We're just, offline here just a couple minutes ago. And, we talked about so many different topics and, I wish we had enough time to cover everything, but, unfortunately we don't. So we'll try to, pick some of the good topics and provide our the audience with some good information and, especially some information that they can use in today's situation, with COVID-19. We'll discuss that as we get there. But before we get there, I'd like to maybe you can introduce yourself and give us a little bit more about your background and who you are. And I gave you a little bit of an intro, but I know that you guys do a lot more than that. So tell us a little bit more about yourself.
Sure. So Gibbs Giden, we're a mid-sized law firm based in Southern California, 4 offices throughout Southern California and Nevada. What we focus mainly on, we started as a construction law firm doing construction defect, construction claims, and throughout the years, we've kind of morphed into not a full-service law firm, but anything essentially with real estate. So we help clients from individuals leasing their first retail space because they want to open a restaurant to multi-million dollar syndication deals, whether it's multifamily or another type of commercial asset. And we help investors through the whole process, negotiating the purchase and sale agreement, due diligence, getting financing for the property, syndication documents, if that's what they're doing, all the way through leasing and eventually disposition of the property.
So yeah, you guys do a lot of different transactions. You guys do a lot of cover a lot of different areas and help a lot of different people in both on the residential and the commercial side, which is very interesting and very good. So let's dive right into it. I know that there's a lot of different areas that you can cover. We're going to cover some of the mistakes that people make. Maybe on purchase and sale agreements. You also do syndications. We'll get to that topic here after this. But what do you see is the most common mistake that people make on purchase and sale agreements that you see over and over again that people can easily fix, but it seems like they just don't they don't get it on the first shot?
The biggest one is probably not reading through it. Especially, I'll use California as an example. When you're talking about maybe a very small property, maybe a 2 to 4 multifamily unit. In California, we have something that our California Association of Brokers puts together, and people will sign it without really reading the terms, just as if they were buying their first house. As you get into bigger properties, then you start getting into more complex agreements, but it gives you the benefit of actually reading and someone looking at the terms. And so besides actually not reading it, or just thinking that it's a standard agreement, say the number one thing is not paying close enough attention to representations and warranties. And no one really pays attention to those until they need them. So, for example, from the buyer side, you may not pay much attention, if this is a large multifamily property, say 200 units, and there's a gas station next door. There may be underground migration of contaminants, and we want to get representations from the seller that they're not aware of any hazardous materials, that they're not aware of any litigation and a host of other issues with the property, because you're not in your due diligence period, depending how long it is, you may not be able to discover certain things until you're actually into the property and it's 6 months to a year later. And without negotiating these representations and potential ongoing liability of the seller, you may have no remedy. And that affects you, that affects your investors, your reputation, because while you may have thought you did a thorough due diligence process and you thought you looked into everything, there are certain things that you may not be able to discover till later on. And those representations and warranties from both the buyer side, getting what you need, and the seller side, trying to limit those to what you actually know, it's important, and it really comes into play when you discover something later on, and it's worth it to take the time and not bypass that when you're negotiating these purchase and sale agreements.
Yes, and especially as a new buyer, I can see maybe how people would want to just kind of breeze through it and just sign it and be under contract on a new property, right, for themselves, because they had the anxiety of getting that first property. But it's very important to stay clear, stay focused, and read through the whole entire thing. And if you don't understand what you're reading, then that's what you guys are there for, right? You guys are there to be able to read through that language and be able to clarify what things mean. That's more on the buy side. What about the sell side though? Like if I'm selling a property, is there anything that I need to protect myself from or be aware from a possible buyer's situation? I mean, is there anything, or is it more to protect the buyer?
No, absolutely. It's both. And from the selling side, probably the number one thing, while it's related to the representations and warranties, is you want to be able to walk away from the property when you sell it. You've sold it to the buyer. You don't want this lingering headache and think that 10 years this buyer is going to come back and sue you when you may have distributed money to your investors. You may have wound down that entity and moved on. So you really want to try to work into a cap or a ceiling on any liability. So, for example, that hazardous materials claim, say the buyer had a claim against us as the seller, we may want to limit that to, say, 3% of the purchase price. So if this is $1 million property we're selling, my maximum liability might be $30,000. So while there is a potential claim, if the buyer ever made one, I know that that's the maximum amount of my exposure. And that's something we negotiate all the time. It can be contentious between buyer and seller, but in bigger commercial deals, it's become more standard to have this type of cap on liabilities, and also a time frame, so that, like I said, this isn't going on for 5 years. You may have a 6-month or maybe even a 12-month window to make these claims. And after that, I, as the seller, can kind of wipe my hands of the property and wind down my entity, make final distributions, and know that I don't have any lingering or ongoing liability.
And, that's a very good point, because it's not something that we think about, right? We think about, hey, where the property sold now, our investors made a healthy return. Everything's great and dandy. There's a lot of sun and beautiful skies, and we're moving forward, right? But then you never know what happens or what can happen with a potential buyer, down the road. And that's a very good point that you bring up, though, because you do have to cover yourself. And it's not the number one thing that you think about. You're thinking, okay, you're closed, it's closing day, and it's over in the story, right? But there are some things that could linger and could come back to bite you if you're not well protected, right? That's very interesting. Yeah. So a good thing to note there. What about on the PPM side, right? So I know we're kind of skipping here a little bit, but on the PPM side, I know that you guys focus on syndications. You guys deal with syndicators as well. Is there anything specifically that syndicators need to be aware of whenever they're drafting the PPM, or whenever that process gets drafted?
It's, to use the kind of phrase from real estate when you're talking about buying a home: location, location, location. In PPMs, we say disclose, 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 because the main purpose of that document, and there are some circumstances where you may not even need a PPM, but we always recommend you do it, because that's your shield versus a deal gone bad, and especially an investor that was really relying on that return and they don't get it. In the PPM, that's where you disclose your risks to the buyer. You say, my returns, these aren't guaranteed. These are what we anticipate, and you use words that don't show a guarantee. We're projecting, we're anticipating, because if it's a great deal, everyone's happy, it's perfect. We don't need to document anything, but we're preparing these documents for that one bad apple out of the 100 deals where it goes poorly. And maybe it's circumstances like today with everything that's going on, where it's outside factors beyond our control. But we're disclosing these risks to our investors. We're outlining what our projected returns are. We're disclosing what our anticipated time frame is. And that way, if a deal does go bad, I, as the sponsor, I hold up my PPN to my investor and says, look, I disclosed all of these risks. You knew all these risks going in. I made all my proper filings. I did everything by the book. It was something out of my control. It didn't work out. And that protects you as the company and your other investors and you as the sponsor from a potential litigation claim from a spurned investor.
Good point. So on that same note, you just covered that a little bit, and that's one of the things that we wanted to discuss here today was how situations have changed since this outbreak, right? Since the COVID-19 outbreak, and we're going through a lot of different situations where there's people that are under contract and their terms changed, right? And this could be on the lender side. It could be situations changed. They couldn't get to the property to do proper due diligence, and so. People were going into a contract and they didn't have those, clauses in there or the specific language to protect themselves as buyers. And then all of a sudden they have, all these situations going on. And so is there anything that they can do? Is question number one, I guess, anything that they can do. Question number two is for people that are just now going under contract or looking to buy a deal, what can they do to be able to protect themselves? Because as I mentioned, not only have things changed on the property level, but also on the debt side, things have changed, and it seems like hour by hour things are changing constantly. So, tell us a little bit more about those.
You're absolutely right, and things are changing hour by hour. We've had, in LA County at least, we've had the state, the governor, and then the mayor coming out with one order, and then 6 hours later, it's expanded or changed. So. It is a fluid situation and we're learning more as time goes on. But for those investors currently in the deals, I'd say the number one thing is communication. So if you're unable to get into a multifamily property, to get into units to inspect it because the tenant is not allowing you in, that's not something that you as the buyer did wrong, nor the seller, but the buyer shouldn't be penalized for that. So to the extent your contract doesn't have a force majeure clause, which is the word kind of been throwing around, but what that clause means is you're unable to perform a certain act because of government strikes or lockdowns or earthquakes, tornadoes, natural disasters. But a lot of times now you're seeing that pandemic may have been included in that, and that excuses certain actions. So to the extent you're not able to get into a unit because of that, because you're unable to, that would excuse that action and potentially give you more time. And even if you didn't have a clause like that, there's a legal doctrine which was hardly ever used, but now it's kind of coming out of the word called impossibility. And I've never really used it, or I've seen it, but never used it in my legal career. But now I'm seeing it. And what that's essentially saying is I'm unable to perform my obligations under this contract because it's impossible. And if a tenant is not letting me in their space because they're scared of getting sick or contracting this virus, I can't do it. It's impossible. So I go to the seller and I need more time, or you need to work with me in getting this estoppel certificate, or letting me inspect this, or getting this more time for this rent or this obligation because of the situation that we're in.
Okay, so is this a nationwide type of situation to where you can protect yourself, or is this like for the state of California?
They're getting to be nationwide. So every state and essentially city is different at this time, but they're coming out nationwide. I used California and LA County as an example, just because besides New York, we might be a little bit further along in the pandemic process. And that example, kind of dovetail in commercial and residential real estate. We have essentially deferred rent payments if you're unable to make them because of the pandemic. And you have, depending on where you read, which I say everything is changing, somewhere between 3 to 6 months to pay that back. So that is not, it's going from, renters that essentially may have lost their job, unable to pay, up to landlords. Now they're not getting rent. What kind of situation does that put me in with my lender? And I know Fannie and Freddie have both instituted, that same kind of 3-month payback period, but not necessarily all lenders, because it affects the landlord too. If I'm unable to pay, if I don't get rent, I'm unable to pay my lender, and then it's going to go up to the lender. If the lender's not receiving those payments, that comes back to the individual borrowers. So we are expecting some type of regulations to come down, hopefully universal, because every area is different. Even in California, from one county to the next, you're getting different moratoriums and different examples. But to your other question, just to jump in, if you're going forward and you're entering into a contract now, it's something that you want to think about, whether adding in a much longer due diligence period, adding in options to extend, protecting your deposit, just because we don't know how long the situation is going to be. And we don't necessarily know, if it keeps going on, you may not be able to get into a property to view a unit in a month. So it's constantly changing.
And those are some very good points. And specifically, we're in a contract on a smaller deal, right? And this is a smaller deal with just between or among a few people. But one of the things that we added into the contract, and I guess timing was a big player in this, because if it would have been 2 weeks prior to that, then we wouldn't have added this clause or this language into the contract. But being that it was just in right in the time where things were kind of starting to go a little crazy here in the States, we added this language in there to where it said specifically COVID-19. If we were not able to go into units because we can't do proper due diligence, go into units, then the seller has to be able to be more flexible, and they have to be able to provide more time. And it extends the due diligence period until we're able to do proper due diligence. But also, in addition to that, like I said, the trades, those guys have to get out there and inspect and do their part to be able to tell us what they find with the property. And a lot of times they can't go out there because of the same situation, right? So those are some things that you have to be able to add into your contract. And I'm not an attorney, obviously, but just make sure that you do try to get that negotiated into your contract. The other thing about that is on the debt side, right? And on the debt side, we're seeing things change like quickly, right? And this is day by day, hour by hour, as we mentioned earlier. Some of the things is for example, where lenders are requiring us to have 12 months or 18 months, depending on the loan amount, of principal and interest. So this is your debt service, of taxes and insurance, and replacement reserves. So depending on the loan amount that you have, they're requiring you to have that, and that's not something that you accounted for at the very beginning. So it's something that can really hurt you. It can really change your returns, so to speak, if you have to raise that money and it's just going to be sitting there doing nothing, right? So it's not really putting the work. So it's very, very important that you know and you try to cover yourself as much as possible whenever you're negotiating a contract. And that's why guys like Jeff can really help you out, and they can go to bat for you and do everything that he can to be able to protect you as best possible. So that's just something to add there, because things are changing on a constant basis, and just another thing to be able to know about that we didn't have to worry about just a month ago, right? So besides this situation that we're going through right now with COVID-19, anything else that we have to know about, or any other mistakes that you see that people make, both on the buy side and on the sell side, of any residential or commercial transactions?
Not necessarily on in a purchase agreement or a PPM, but one of the biggest issues we see even before COVID-19 is not really having a good team in place. As a first-time investor, we may be listening, learning, and we just want to get our feet wet and jump in. But I think what I've seen a lot, especially with first-time investors, is jumping in too soon. So maybe, and like I said, not having your team in place. So you want to make sure we've got a good insurance broker, because one slip and fall could wipe out all my returns, could wipe out equity in my property. Do I have a good accountant? I see so many times money left on the table, especially with bigger projects. If you're talking about cost segregation or other creative accounting means, if you have a good accountant, you're keeping all of that money in your investors in pockets. And not to toot attorney's horns, but you do want a good attorney as well, because they're the ones that see the problems. You as the investor and sponsor, hopefully you never see these. You get a good attorney and they've seen what can go wrong, and they can protect you by putting in certain language in your PPM or purchase agreement that hopefully you never see and you never have to call upon it, but it's there if you need it. So it's really getting that team in place and kind of thinking through your deal before you jump into it, whether it's making sure I have the right entity. so I can save on taxes and make sure that I'm being efficient, making sure that I've disclosed, my risks to my investors, and making sure that I kind of think through the life cycle of my project. And, what's the hold period on this? What am I going to do in the situation? What am I going to do? If investors leave, do I have the ability to bring on more? Just thinking through the project. And that, I think, is probably the number one thing to protect yourself, and the best advice I can give, because thinking ahead helps you avoid the problems, and it helps your deal be as efficient and keep as much money in your pocket as possible.
Exactly, and that's definitely the goal. So what about on the lease side? I know that you guys also represent people either people on leases as well, right? So this is residential and commercial. You guys do both?
We do both. On the residential side, residential leases fortunately are simpler than commercial, just given what they are. The important one on residential, I'd say the number one thing you want to pay attention to is really the default provisions. You want to make sure if your tenant is not paying rent or has abandoned their premises or is creating waste or nuisance, and affecting other tenants, that you have the ability to get them out properly and quickly in accordance with your state's laws. Because if you don't do it by the books, they can challenge any eviction, they can stay in the process, and it's just a nightmare. And not being able to get out a problem tenant on a residential side, it's not just the lost rent and that particular unit, but to the extent, maybe it's a nuisance, they're doing something, illegal in there, or just very loud, they have, pets they shouldn't have, it affects your other tenants. And, that can just create a snowball effect. On the commercial side, you're dealing with, typically more sophisticated parties. It might be a bigger landlord, not necessarily, maybe a mom and pop. Instead of individuals, you're dealing with companies. So when you're negotiating commercial leases, a lot of it changes. Well, the default provisions are still, very important and then negotiated over. It's also looking a lot at what can the landlord pass through to me, because you negotiate your base rent, and that's kind of like the rent I'm paying for my apartment. But in commercial leases, the landlord's passing through their operating costs too. So their real property taxes, their insurance, a lot of the maintenance, and a lot of times landlords may be charging for certain things that they shouldn't. So it's worthwhile to read through those provisions and making sure that you understand what the landlord's able to charge you and what they're not, and also how long they can charge you them for. I've got a deal on my desk now where the landlord is going back 5 years because the tenant, missed a couple $100 in operating expenses here. The rent didn't go up by $10 there. So they're going back 5 years. And that can really affect me as the tenant or business owner, because I haven't planned, I'm budgeting, I'm planning. This is now an unforeseen expense that I have to go back and pay X amount to the landlord 5 years later. So it's really going through time periods in a commercial lease and making sure that they're reasonable, and I'm not going to be, bombarded with cost or something, years down the road.
Yeah. And so I'm trying to figure out what are the ways someone can protect themselves on that type of situation, right? If somebody could go back 5 years or 5 years ahead, then what do you do there? What are the ways can you protect yourself in that situation?
One of the things is putting a cap on the time period. Mm-hmm. So if the landlord doesn't give me an invoice for certain expenses, say within 12 months, that they're waived. So that way he can't go back 5 years. One is capping the amount that operating expenses can increase from year to year. So we've got variable operating expenses and fixed. And the variable ones might be, if it's snowing, we might need a lot more, plowing and certain things than other years. But we can cap those variable expenses from year to year. So say they're only going to increase 3%, rather than, all of a sudden this year my expenses increased 20%. That really affects me. So limiting landlord certain actions in terms of increased expenses being passed through to the tenant. That's the monetary one. The other issue I'd say in commercial leases, especially if you're a business, is look at the assignment clause. Because one, if my business goes south and I've signed in commercial leases are for a much longer period. Typically, they might be 3, 5, 10 years, while your residential lease might be 1. If I'm stuck in a commercial lease for 5 years and my business isn't doing well, I may have signed a personal guarantee and I'm stuck. So I want to make sure that I'm able to get a real estate broker and market the space to someone else to try to get out of it. Or maybe I'm selling my business and I'm selling all of my locations, and I don't want my landlord to say, I can't sign my lease to, John Smith down the street, because then he can affect me from actually selling my business. So it is important to really look at the assignment clause as well to see how I'm able to get out of this lease or assign it to a new party.
Yeah, and this is not something that we discuss too much here on the show, but this is very, very interesting because, these are also, transactions that, people or, type of situations and type of investments that people like to make as well, right? So not just multifamily, because we discuss multifamily for the majority of the time here, but also on the lease side, and we're talking about, double net, triple net leases where, the tenant is going to be responsible for so many different aspects to it, taxes, insurance, repairs, you name it. But also the clauses that you have there, right? The assignments. Now that's something that's very, very important to have in there. If I have a business, like you said, and I'm ready to sell, or situations change and it's not going well for me, maybe, timing right now, COVID-19 is that I have a retail business and this next guy is planning to do some kind of health care facility and that's in need, then, I need to be able to assign it. I need to be able to move on from the business. And so you have to be able to see what your clauses say in that. Very, very, very interesting. And something that we don't necessarily think about all the time, but it's out there and it's very important that you're aware of that. Okay, great. Any other thing that we have to be aware of that you can think of, just like more, doesn't have to be in leases, but anything else that you see that people make all the time?
I think right now, you can't not talk about the COVID-19 to jump back to that. And now with everything that's changing is, we talked about communication. It's, any new deal that you're entering into should, especially, at least in the next month, should have some type of reference to that to give you additional time, because, while we're doing other deals, a lot of the questions coming in now have to do with that and timing. And even if this pandemic ends, next couple months, we're going to be dealing with these issues, insurance issues for lost rent, business interruption for, I gotta say, the next year. So it's anything new that you're entering into, make sure you've read through it, that you're comfortable with the timing. And, current tenants, if you're a real estate company and you have an office lease with you and your employees, think about, taking care of your employees and, whether you have the money to pay rent, because a lot of states are going to be giving these deferments to let you pay it back over time, and it could ease cash flow crunches. So, just pay attention to what you're signing and make sure that you're thinking, I know we've talked about it at length, but thinking long-term, especially in these next couple months.
Yes. Yeah. Another very good point is not just for the next couple of months. I mean, this thing could drag on for a long time, but also the effects, the aftermath, that part, it's what really can drag on for a long time. Very, very important that you have the right team to be able to help you out with that. So Jeff, it is time for our nuggets of wealth. These are questions that we ask every guest every week, and hopefully they are able to help out the audience. So question number one for you is what is a good tool, source, or platform that you use almost daily at your firm or even personally that can also help others?
Especially now, I'm going to say Zoom, because
yeah.
I can't not, because all of our, communication is now, remotely. And I don't think there's a substitute for seeing someone in person or picking up the phone. So much now is done through email. And with real estate deals, a lot of it's personal, a lot of it's reputation. So to the extent you're able to talk to someone or see someone in person rather than sending an email, you get that connection, and it's gonna help you negotiate deals and get better results.
No, I agree. I mean, Zoom is a great resource. It's a great platform. I mean, obviously, that's how we are recording this interview right now as well through Zoom. But if you can't see yourself, you can't see in person, you can't meet in person. This is the next best thing, right? There really is no way around it, especially during these times. But it also makes it more efficient. maybe you can, set up a meeting, but in person, but you can do a quick, online, Zoom call, right? So it's very, very important. I like the platform. I use it all the time. And so I second that as well. What's the best general legal advice, if you can give it legal advice, that you can give to the audience? Just something generic, the best legal advice you can give to people out there.
Don't know if it's legal advice, but especially, again, where we are, I'd say check your insurance. I mean, make sure that you are up to date on insurance, not just because of the pandemic we're in, but, making sure that you've got casualty insurance and you've got liability insurance, more so even in the multifamily context. You've dealt with so many, slip and falls, or a party where, someone might be, drinking, or someone, falls off a balcony, or you have a delivery man coming up to a door and slipping and falling. If you don't have the proper legal structure in place, your fallback is insurance. And I've seen, investors and sponsors, wiped out by claims just because they thought they were adequately insured, and they're not. So although it's not legal, protecting yourself that way is one of the best things you can do, and making sure that you've got the right insurance, the right amounts, and that your policies are up to date.
I agree. That's very good advice. So what's a good resource for people to stay up to date, with some of the latest legality concerns, or up to date, changes that happen in the legal world? Is there a platform or website, or where can somebody just, find out a little bit more information just on the legal side?
On the legal side, a lot of law firms, ours included, we've got kind of blog posts and legal updates when we, because you run-of-the-mill investor or individuals not going to want to read all the statutes coming down from the state. To the extent your lawyer, your law firm, or, check out ours, check out LinkedIn, because we've got people, myself included, that are reading those and summarizing those so you can understand, what's happening with when. And you kind of get the nice summarized version with the key details, rather than reading the dense, 20, 30 page statute that's coming down.
Got it. So specifically, where can Commit to Wealth Nation go to contact you and find out more information about your law firm and your blog?
You can check out our website for one. It's gibbsgiden.com. Also, feel free to email me. It's jlove@gibbsgiden.com. And you can call me as well. Always happy to answer any questions, especially with what we're going on with now.
Yes. Okay, so we're going to put that in the show notes, gibbsgiden.com, jlove@gibbsgiden.com. And then, I guess, people can also reach out to you on social media, as well. So Jeff, thank you so much for your time. I really do appreciate it, man. You really have gone through a lot of different topics, but a lot of very important topics, a lot of good things that we have to know about, especially during these days, as you mentioned. It's all about in writing the contracts as best possible. It's all about the protection. You talked about the insurance, making sure you have enough casualty insurance as well. And so many different things that we have to have to be able to be better protected out there. So thank you so much for your time, and I wish you continued success in the business. And people, reach out to him. He really has helped us out here a lot. And if you are looking to start your own business, if you're looking to buy the deal, if you're looking at different leases, Jeff can really help you out and give you some good advice there as well. So thank you so much, Jeff, and I appreciate your time.
Likewise. Thanks for having me again.
CommitToWealth.com, creating a legacy by committing to real estate wealth.